Data privacy and compliance understanding this is non-negotiable for anyone working in AdTech today. This module covers what may be the most consequential shift in the history of digital advertising: the privacy reckoning. For years, that tracking happened largely in the background, without users having meaningful knowledge or control. Let's start with the core problem. AdTech's power comes from data. The more data you have about a user, their demographics, interests, browsing history, purchase intent, location, the more precisely you can target ads to them, and the more valuable each impression becomes. The issue is scale and opacity. AdTech platforms collectively track users across hundreds of thousands of websites and apps. Every page load, every search query, every app open generates data. This data is combined across sources to build profiles far more detailed than most users realize. And historically, this tracking happened without meaningful consent, buried in privacy policies that few people read. Real consent is rarely obtained. Pre-checked boxes, buried opt-outs, and privacy policies written by lawyers for lawyers have meant users had no real understanding or control. The same infrastructure that enables targeted advertising can be used for price discrimination, political manipulation, identity theft, and surveillance. These aren't theoretical concerns, they've happened. The industry has had to reckon with all of this, driven by regulation, browser changes, and growing consumer awareness. Let's look at the specific regulations that are reshaping AdTech. The General Data Protection Regulation, GDPR, is arguably the most significant piece of technology regulation in history. It didn't just change how European companies handle data. It changed how every global company that interacts with European users handles data. GDPR establishes 6 core requirements for any company handling personal data. Consent. You must obtain explicit, freely given, specific, informed, and unambiguous consent before collecting personal data for advertising purposes. Transparency. You must clearly disclose what data you're collecting, why you're collecting it, how long you'll keep it, and who you'll share it with. Data minimization. Collect only what you actually need for the stated purpose. Purpose limitation. You can only use data for the specific purpose for which it was collected. User rights. Individuals have rights to access their data, correct inaccurate data, delete their data, the right to be forgotten, restrict processing, and receive a copy of their data in a portable format. Data security. Appropriate technical and organizational measures must be in place to protect personal data from breaches and unauthorized access. The most important U.S. privacy law is the California Consumer Privacy Act, CCPA, and its successor, the California Privacy Rights Act, CPRA. California has the world's 5th largest economy, so laws that apply there have enormous national and global impact. CCPA gives California residents 4 key rights. The right to know what personal information is being collected about them. The right to opt out of the sale or sharing of their personal information. This is what powers those "do not sell or share my personal information" links you see on websites. The right to request deletion of their personal information. And the right to correct inaccurate personal information. Now COPPA, the Children's Online Privacy Protection Act. This is a federal law that specifically protects children under 13 online. For AdTech, COPPA has strict and concrete requirements. You cannot collect any personal information from children under 13 without verifiable parental consent. You cannot target advertising to children without that consent. The U.S. privacy landscape is evolving rapidly. Several other states, Virginia, Colorado, Connecticut, and others, have passed their own privacy laws, each with slightly different requirements. The absence of a single federal law creates compliance complexity, but the direction of travel is clear: more regulation, more user rights, less unconstrained data collection. First-party data, data you collect directly from your own users, is increasingly the gold standard. Third-party data is collected by companies other than the one the user is interacting with and shared across different websites and platforms via tracking mechanisms, primarily third-party cookies and tracking pixels. Google, Apple, and Firefox have all taken steps to limit third-party cookie tracking. The industry is racing to build a cookieless future. For advertisers, this means building direct relationships with users, logged-in experiences, loyalty programs, email lists, app ecosystems that generate first-party data. For publishers, it means investing in authenticated user experiences. The companies that build strong first-party data assets now will have significant competitive advantages in the privacy-first future. That wraps up Module 7. Let's quickly recap what we covered. The data privacy problem in AdTech GDPR U.S. privacy laws, CCPA, CPRA, and COPPA first-party versus third-party data.